Well, still to another big story this hour, and that is the Supreme Court has just ruled that IEBC Chairman Wafula Chebukati cannot amend election results. In a ruling delivered a short while ago, the judges said that Chebukati can only flag off errors in the results. Let us now get to hear what the judges said in their ruling.
Exceptional circumstances as enunciated in the Court of Appeal case of Ngurumani Limited had not been met. Thus, this court should disallow the application. On the issue of costs, the Law Society of Kenya's submission is that this court should not award costs on an application concerning a matter in which a party seeks purely to be guided on its state officer duties. However, during hearing before us, Mr. Mwenesi, advocate for the Law Society of Kenya, rose to highlight his client's submissions. However, during hearing, before Mr. Mwenesi, advocate for the Law Society of Kenya, rose to highlight his client's submissions, Mr. Karori, advocate for the second respondent, raised a preliminary objection as filed on the 11th of October 2017. The objection sought to expunge the submissions by the Law Society of Kenya on the grounds that they had exceeded the scope within which the said society had been admitted as an amicus curiae. Mr. Karori submitted in that context that the Law Society of Kenya was expected to limit its submissions to the interpretation and application of Section 83 of the Elections Act, but had instead responded to the application and taken a partial position. That an amicus curiae is not supposed to pursue an active position and outcome, as that is left to the parties to the dispute. On that submission, Council relied on this court decision in Trusted Society of Human Rights Alliance versus Momo Matemo and 5 others. Mr. Mwenesi was, upon the objection being raised, accordingly guided by the court to limit his submissions to the interpretation and constitutionality of Section 83 of the Elections Act. He thus submitted that in compliance with the law, the result notwithstanding, the first respondent has not set out any ambiguity in Section 83 as interpreted by this court to warrant the present application.